There we go. So good morning, everyone. I'd like to begin by acknowledging that we find ourselves on the lands of the Matagami and Batachewan First Nation, the Treaty 9 territory. I want to take a moment to acknowledge the importance of the lands that we call home. As an organization, we do this to reaffirm our commitment and responsibility to improve relationships between nations and improve our own understanding of local Indigenous peoples and their cultures. This is why for the past 16 years, the Chamber has extended complimentary membership to our First Nations in the region to stay connected and support in any way that we can. From across the province, we acknowledge the ancestral, unceded, and unsurrendered territory of all the Inuit, Métis, First Nation people and commit to the principles of truth and reconciliation. My name's Carmen Swartz. I'm the Manager of Business Services here with the Chamber and happy to host this morning's session under our Reimagined Resiliency series, proudly supported by Newmont Porcupine. Our session today, Employment Law in Your Business, is supported by our succession pillar partners, Genie Financial, Maisonneuve, Dawkins Lawyers, and MNP. Thank you, Suzanne and Robert, for sharing your expertise with our members and small businesses who've joined us via our 32 Northern Ontario chambers from Temiskaming Shores to Kenora. I'm just going to let these attendees in. So for those of you who've joined us today, you're welcome to ask your questions either in the chat, or if you prefer, you can go ahead and unmute and ask questions as we go in this morning's session. So without further ado, I will leave the floor to both Suzanne and Robert this morning. Thank you.
Hi, good morning. Thank you very much for having us.
Good morning.
Perfect. We have prepared a short PowerPoint presentation, which I'll get up on the screen. And we'll get that in presentation mode. Is that looking how it should?
It is. You're all set.
Perfect. Okay. So thank you for having us. Thank you for the introduction. My name is Robert Jones. I'm an employment lawyer. Been working with Suzanne for about 3 years now. And Suzanne, I'm sure needs very little introduction around here, but I'll let her say a few words about herself as well.
Yes, my name is Suzanne Desrosiers, and I've been practicing for 38 years, and I would say for the past 22 years, I've been very much involved in employment law. I also practice in other areas of law, such as real estate and estates, but a good portion of my practice is employment law, both at the federal level and at the provincial level.
Excellent. So this presentation that we prepared today is geared towards provincially regulated employers because that's what our audience overwhelmingly is. We welcome questions from participants at any point during the presentation if you want to filter them through in the chat, or just unmute yourself and feel free to get involved. I don't expect that it will go all the way to 11 today, but we'll see how we're doing with the time. So we've prepared a couple topics, and the title of the presentation, legal changes that impact businesses and employment law and your business. Suzanne and I are both very passionate about employment law. Okay. So the first topic that we wanted to cover today is fixed term employment contracts. And we work with a lot of organizations that use fixed term employment contracts, and particularly a template agreement that you might have had prepared by a lawyer at some point, or maybe you've obtained it from some external type of internet provider that provides human resources type documents. I know lots of these are cropping up nowadays. And you get these templates and, you use them for all your new hires, and for the large point, most of the time, you just kind of change the name and the rate of pay and the start date, and you sign on the bottom and you ship them out, right? And there can be a lot of problems with doing that we've seen. Business is what we do every day. We see them happen. We advise people that find themselves in these type of situations. And of course, there's been a lot of very recent case law as well. And some of what we've included in here, we have a decision from 2023. We've got 2022, very recent stuff. I read these cases as they're coming out. Suzanne as well, very up to date with the sort of latest trends in this practice area. And so we chose to talk about fixed term employment contracts as part of the presentation today, because we know that a lot of organizations like to use them.
Okay, so basically, to understand what a fixed term contract is basically a fixed term contract is a contract that has a start date and an end date. And often what we see is the reason behind doing those types of contracts is you see that in organization that they will receive funding for a year or two, and they're concerned of having to pay termination pay and severance pay because the funding ends. And the thing is that by doing that, they often get themselves in a real bad situation, because they're under the impression that they're covering themselves and they're protecting themselves. But the problem with those fixed term contracts is that if we're not happy with the employee, and we want to terminate the employee, the thing is that for the most part, you're going to end up having to pay the balance of the contract. So let's say, for the sake of an example, that you've entered into a contract of 2 years, because that's the period of the funding that you'll get. And 2 months into the contract, you realize that the employee that you hired is not the proper candidate for that task. So that you decide, well, I want to terminate this employee and find somebody that is more suitable. So if you've gone ahead with a fixed term contract, you can expect to pay the balance of the term, which would be here 22 months of, in my example, 22 months of service, if you want, and you're getting nothing in return. You're not getting no work. You've basically lost the funding. The funding that you're getting is all going towards this employee that you've terminated, and you're not getting the benefit of the work. Had you, on the other hand, hired this employee on an indefinite contract, and after 2 months realized that not a good fit, you could have terminated this employee at no cost whatsoever. So that's an example of why a fixed term contract is dangerous. The other thing too is, in the fixed term contracts, sometimes they do 3 months at a time, 6 months at a time. Well, a contract that is typically renewed over and over again, from the court perspective, they're considered an indefinite contract. And an indefinite contract, the document you have before you is only a fixed term. So that means the termination provisions are not set out. So you basically end up with a situation where, if you do want to terminate, and this is the 5th year of doing this 3 months, 6 months, you're going to be faced with common law notice, as opposed to a termination clause right in the contract that could limit it to the Employment Standard Act, or even being a little bit more generous. So the thing is, the moral of the story, as you'll see in a bit, is could be a costly proposition.
Mm-hmm. Yeah, no, we give this message a lot, and it's always, I understand it's very counterintuitive, because you think that you're protecting your business by using a fixed term employment contract. And in actual fact, it's a fixed term employment contract is something that I try to negotiate for an employee who is thinking about changing jobs from an existing steady job that they've held for a number of years they're thinking of signing up with a new employer, and maybe that employer has actually approached them and suggested that you should come with me. If I'm advising an employee in that spot, one of the things that I will suggest for that employee to try to negotiate is to get a fixed term employment contract with the new employer, because it provides a measure of job security. What you have to understand is when you enter a fixed term employment contract, you've promised that employee that you're going to continue their employment for that fixed term length of time. When we use the word indefinite, indefinite just means there's no fixed end date. It's going to continue until either one person decides to resign, or the employee decides to retire, or the employer initiates the termination of the agreement. And we don't know when we sign up when that's going to be. And the vast majority of agreements are indefinite employment agreements. So that's important to understand. When the employee has a reasonable expectation that employment is going to continue, either because their contract keeps getting renewed over and over and over again, that's an indefinite employment relationship. Okay. We generally advise employers to just get away from using fixed term contracts, but don't take our word for it. We've got some recent cases to show you that of the dangers of kind of what we're talking about. Okay, so as we're kind of getting at in this slides here, right? Often the idea is we'll expose ourselves to less. We're limiting our obligation towards the employee by keeping them on a fixed term of employment, right? That's why it's counterintuitive. I understand from a business perspective why it seems like that, but from a legal perspective, it's actually precisely the opposite. So contrary to popular belief, fixed term employment agreements, especially these template ones that you got from I don't know where, and you just change the start date and the pay, and you can run into a lot of problems with using those. Okay, now the law does say that you can have a termination clause in a fixed term employment contract to allow you to bring it to a conclusion earlier than the date that you specified. Okay, but then you need an enforceable termination provision, which is good luck with that. And I'm not trying to be cute, but very difficult with the recent law, and I'm going to discuss with you. Okay. But what the common law says generally, like I said, okay, one of the examples I like to give people to help wrap their minds about this, okay, think about if you agree to sign up for a lease, you're going to rent a place, a residential, I'm not talking a commercial, a 1-year lease typically that they want, right? Well, you've promised you're going to live there for a year, right? You're not free to just decide after a couple months, I don't like this place, right? That's a fixed term agreement. And it's the same thing with a fixed term employment agreement, okay? If you contract that you're going to hire this person for be it a year, 6 months, 2 years, that's what you've promised to do. And that's their reasonable expectation that you're going to continue their employment for that length of time. And if you don't do that, if you breach the contract by bringing it to an end before the end of the fixed date, then presumptively at common law, you're liable to keep paying them the salary that they would have earned all across the end of until the end of the agreement. And that number is way more often than not, a lot more than what you would have paid if you had just simply used an indefinite agreement. And that's the counterintuitive part. You thought you were protecting your business, but then you find out when you get a demand letter, and I was just away on vacation. I've got a few of them I've got to deal with now getting back, asking for much more money, right? Okay, so as we're saying, presumptively at common law, if you're the employer and you terminate your employee before the fixed term that you've agreed to under the contract, you need to pay them for the balance of the contract's term. And that doesn't mean that they're not doing work for you anymore. So as Suzanne said, using the example of 24 months, you've terminated somebody 2 months in, you owe them 22 months of salary. What do you get in return? Nothing. And it's even worse than that, because at common law, there's an obligation to mitigate your damages, which means that the employee who's been let go after 2 months has to go out in the job market and try and find a new job to replace that income, right? And so they wouldn't have a claim for the full 2 years if they, let's say, managed to find a new job at the same salary level 6 months later. well, then their claim would be for the 6 months, the difference between when you let them go and when they found their new job. But under a fixed term employment agreement, there's no obligation to mitigate damages. Okay, you promised that you're going to pay them for 2 years, full stop. Wow, and let's look now at the case where we saw exactly that happen.
Okay. So it's a New Brunswick case. It's the Dornan versus New Brunswick case. There was some, it appeared in the news at one point, I believe it was last fall. Anyway, in this case here, there was a Dr. Dornan that was a medical specialist for 34 years. And he had taken a position as an interim CEO for the Horizon Health Network. And basically, he had applied to be the permanent CEO for that organization. And here the negotiations for the position as the permanent CEO, they did it through an exchange of some texts between them. They negotiated the salary, they negotiated the benefit, they provided for car allowance, they provided for pension. And here they set a 5-year term. And that was very important to Dr. Dornan because he was basically letting go of his practice that he'd had for 34 years. So he wanted some security of employment. So there was a press release where they announced, the government announced that Dornan was named the new CEO. And a few weeks later, they presented him with an employment contract and they inserted a termination clause in that contract, which had not been discussed before. And Dornan at this point here was feeling very vulnerable. And the reason being is he had let go of his private practice on the strength of the agreement that he was hired as the permanent CEO, and also on the strength of the agreement between them, and there was no discussion of a termination clause. And the thing is that he felt kind of stuck because now he's faced with this employment contract. So basically he decides to sign it, feeling he had no choice because he had already let go of his practice. So basically, he a couple of months later, there was an incident where there was a death of a patient in an emergency room, and that got a lot of criticism and a lot of local media in New Brunswick. And after this unfortunate death, the premier got involved and terminated the health minister, appointed a new health minister, gets Dr. Dornan on the phone, gets his new health minister to terminate him on the spot. And in that termination letter, they offered to pay him a year's salary. And in that press conference where the Minister of Health terminated him, it became very public and insinuated that Dr. Dornan was at part responsible for this death. And so it affected his reputation. So anyway, this matter went before a tribunal. And basically, they found that the 5 years fixed term contract, even though it was oral, an exchange of text, and there was that was the contract was enforceable, and that did not include that termination clause. And the written contract could not replace the oral contract in this case. There was no, in order to be able to change an employment contract and employment law, you need an offer, an acceptance, and a consideration. Let's relate that where consideration in contract law. Give you an example. You offer to buy a house for 200,000. Vendor agrees to sell his house for 200,000, and you've got the deposit. The deposit is the consideration in real estate law, but in employment law, in order to have a valid consideration, if the employee has not started to work, you've got I offer you the position at this salary, you accept the position, and if you have not started the work, the job itself is the consideration. But once the employee has started to work, be it 1 hour, 1 day, 1 week, the job is no longer the consideration. You need to offer something extra. It could be a signing bonus, it could be an additional sick day, an additional vacation day, or whatever, but there needs to be that additional consideration. And in this case here, that termination clause within the contract did not offer that additional consideration. So the court said this written contract, even though it was signed by Dr. Dornan, had no additional consideration and therefore was null and void in terms of the contract. And basically, the adjudicator found that there was bad faith in the manner they dismissed him, in the fact that they insinuated that it was he was in fact, in part responsible for the death of this patient in the emergency room. So in this case, is a kind of an eye opener. The adjudicator awarded $1,793,462. That was for the lost salary and benefits for the remainder of the 5 years. And also they added an additional 200,000 for the bad fate type of, because of the manner of the dismissal, insinuating that he was to blame. So here we're looking at an award of close to $2 million. You may think, oh, well, we're not dealing with doctors in the positions that I'm dealing with. But the thing is, the numbers may be different because the salary is lower, but it's still going to represent a substantial amount.
Yes, we included this case because it's made national media net headlines. It's got a lot of coverage. This is one of the largest severance awards in Canadian employment law history, period. Okay. And, people are talking about it a lot. So, and it fit with our topic of a discussion. But that one point I want to illustrate is I could have just as easily included cases where the result was 100,000 to 300,000 that are affecting businesses, not giant, huge, doesn't have to be the premier whole provincial health department, could be privately held businesses. And we're talking about a year or two worth of salary under a fixed term employment contract. And I can also include, there was a case out of Ontario that's within the last 5 years. McGinty Funeral Homes made a lot of headlines when that one came out as well. And in that case, there was over $1 million under fixed term employment agreements. And so we like to include cases as well, so you can, you don't just have to take our word for it. We do give the advice up front. Sometimes, we hear from the client after it's kind of already gone south. We try to avoid that, but generally speaking, the advice that we always offer to employers is to really get away from and give a second thought to using these fixed term employment contracts. We see so many organizations that we work with that just have this standard template agreement, and we tell them time and time and again, and they're just sold on the idea of the fixed term employment contract. And as I said, I understand completely why the business, but the legal part is counterintuitive, and you're potentially leaving your organization in a very bad spot.
And it's not only fixed term employment contracts, just using templates generally. You think that you may be saving yourself some money, that, you know, it may have been drafted by a lawyer at one point, but if that lawyer is not knowledgeable in employment law and up to date with the law, the thing is that the lawyer in good faith will lead you in error, not because he wants to, but the fact is just not being on top of the cases.
Yeah.
And just to give you some perspective, an employment contract, I would say to you, that was drafted before the pandemic and that had a termination clause that was then acceptable is no longer acceptable. So you're talking in the last few years, the employment law has really evolved. And the reason for that is the courts do not like to have a termination clause that limits the amount an employee will receive on a termination. And under the Employment Standard Act, it's the bottom of the barrel, it's the minimum. And people tend to want to go for the minimum. And just to give you a quick example, let's say we are looking at a 20-year employee management and in their 50s, just to give you a sense, a court under the Employment Standard Act, this employee would be limited to 8 weeks of salary plus benefits. Court don't like that, saying 20 years of service and that's all they're going to get. So the thing is, they try to, and they always find a way somehow to kick that termination clause to the curb. And employment lawyers always come back and draft it differently so that it could stick. And so take that same employee at common law with 20 years of service in their 50s and management position, you could be looking at 20 months, and possibly a little bit more. And so there's a big difference between 8 weeks and 20 months. So that's why it's important for you to have a valid, enforceable employment agreement that will protect you from that 20 months, but you don't necessarily want to limit it to the bottom of the barrel, the 8 weeks.
Yeah. How are we doing for time? Can we just check in very briefly?
Definitely, it's 10 a.m. You're good.
Perfect. Thank you very much.
You're
Is there
welcome.
questions on the fixed term contracts from the audience?
You can either unmute or put it in the chat at the bottom if you have any questions. I don't see anything now. We can keep going.
Perfect. Thank you. Okay. So let's continue on to our next topic, which is employment law aspects of buying and selling a business as a going concern. Okay. So I'll just give a little caveat here. There's a lot of things that go into buying and selling a business from the perspective of corporate commercial law, tax, depreciation, so on and so forth. We're not going to, and I understand that you may be very interested in a lot of those topics, but those are outside the scope of our expertise and what we are here to talk about you today. What we'd like to talk about is some of the aspects that very often get overlooked in an asset purchase or a share purchase agreement when a business is being bought and sold. And that is what's going to happen with the workforce. Or maybe you do turn your minds to it, which is most often the case, but a team of lawyers that's been put together didn't consult with or consider the expertise and advice of an employment lawyer. And there can be some implications which we would like to discuss with you. Okay.
So basically, as you may be aware, when you're buying or selling a business, it's either going to be a share purchase. That means you're buying or selling the company itself, the shares, and everything that goes with it, which would include the employees. Or it could be that you're buying the assets, and the assets means that you're buying the fixed material of the business, but you're not necessarily taking over the employees, and you will decide to take on possibly some of the employees, but it would be negotiated on a one-to-one with the employees. And you see that in the context that the purchaser may send a notice to the employees saying, we would like to sign a new employment agreement with you. We've purchased the business, and this is our terms, be it at a salary equal or less, maybe not the same benefits that they had, and giving the employee so many days to accept it. And the thing is that the employee is not obliged to accept the terms of the set out by the purchaser. And if they don't, the vendor will be responsible for the termination pay and severance pay that is due to the employee. And that amount is going to depend if they have valid enforceable employment agreements. And just use the example that I used previously of that management employee, you see the big difference. So for the vendor, they really want the purchaser to take on the employee so that they kind of wash their hands from it. While for the purchaser, they have a concern about taking on these employees, particularly if these contracts, employment contracts, and sometimes there's no contracts at all, will make it such that there's a big liability when you take on these employees, because if you decide to terminate them, be it 6 months down the road or 2 years down the road, we're going to count the number of years they worked for the vendor, and we're going to count the number of years that they worked for you. So now we do a combine. So now let's say in my example, this employee has now worked 22 years. Well, the termination pay and severance pay, if the employment contracts are not enforceable, you could be looking at 22 months and possibly more. So again, it's an eye opener. You want to make sure, be it that you buy an asset purchase or a share purchase, that the employment contracts are reviewed and are ascertained that they're enforceable. And that's where, a business lawyer could retain a firm like ours to review the employment aspect of it. And if they're only dabbling in employment law, you're going to get yourself in a real schmozzle of a pickle. And unfortunately, it happens, and we've seen the product of that. In one case in particular, was a share purchase, and the vendor had given a substantial bonus to its employees before the share purchase agreement was finalized. But the way the bonus was set up in the agreement and what was signed with the employee, it was kind of thank you for your good work and working for me for all these years, and here's a bonus. But it didn't have the proper wording in terms of releasing them and considering it as a severance, etc. So the thing is, the purchaser, thinking that this bonus was basically the severance, ended up that if they wanted to terminate, they would have to look at the years they worked for the vendor plus the years they worked for the purchaser. And that was a substantial amount. Why? And that was basically just lack of knowledge. You know, the intention was there. The lawyer that did the business part thought that he had it covered by getting the vendor to pay these bonuses to these employees. And the thing is, it didn't meet the mark. So just as a precaution, the thing is, if you're considering buying a business or you're considering selling your business, the thing is, an employment contract is very valuable. An employment contract should be reviewed annually because the law is in constant evolution. And the thing is that you want to make sure, from the seller's point of view, it makes your business more marketable. Because if the employment contracts are not enforceable, the price goes down. For the purchaser, you really want to make sure that those contracts are enforceable, because, you know, down the road, you may want to redirect this workforce and may want to change some of the employees, and you want to know exactly what is going to be the cost to you if you do decide to terminate them.
Thank you. So we will speak, most of this, what we've set up here was geared towards an asset purchase agreement. Because with the share purchase agreement, it's less complicated. The purchaser essentially steps into the shoes of the vendor, okay? And but it's not so with an asset purchase agreement. So there's the example that Suzanne just gave of a client that we've worked with another one in town where a business was being bought out, and we've represented people who find themselves dislocated. Okay, and there's some different interests at play. We'll go through, and there's again some very recent cases on this topic, and I suspect this will be of interest to some of our members in the audience here, that you may have faced this, or you might, you know, I think this one is quite practical. So, you know, again, you have different interests at play, right? From the vendor's perspective, as of the closing date, they just want the check and they don't want to hear about any more problems, right? They want to kind of step away and have a clean slate. And from the purchaser's perspective, they don't want all these old liabilities of the vendor hanging around. Now we're talking in the context of an asset purchase, right? So what's important to understand is that in an asset purchase agreement, it's a dismissal, it triggers a dismissal of the employment relationship, okay? Because the employees, first of all, an employment contract can never be assigned without both parties' consent, which means I can't say you're my employee now you're an employee of the purchaser. It doesn't work like that, okay? We're talking in the context of an asset, not a share is different because the employee, the legal identity of the employer remains the same throughout, right? It's just the shareholders, the ownership that change. Asset purchase, we're talking about a new corporate entity is going to replace the existing employer. And what we're here to talk about today is, what does the ESA say about you, new corporation, what your obligations owe towards this workforce, and what does the common law say? Because there's been some very recent developments in this area, and some of the results might be something surprising. And again, it can be counterintuitive, just like with the fixed term, because from the purchaser's perspective, it's the most natural thing in the world to think, well, you've only been with me for 2 years. So you think that your obligations are, you know, a couple of years worth of obligations, but it's not necessarily so, okay? So as we were saying, employment agreements can't be assigned, okay, without consent. And an asset purchase agreement, okay, if you sell, as the employer, you sell all the assets, all the inventory, your business has been sold, well, that's a termination of the employment relationship. Someone can't keep working for you anymore because you've sold the enterprise, essentially, right? Okay. So as we're saying, when you see this, typically what's going to happen is that the purchaser is going to extend employment offers to most of the vendor's workforce, not all, but most of them. And what the purchaser is typically going to want to do is replace the top level management, right? Probably like the director of operations, director of HR, CEO, like the C-suite executives. Those are the ones that typically get the boot, and the purchaser wants to install their own top management. But most of the regular workforce that's already familiar with the operations, whatever that might be, whether it's you're operating a manufacturing plant, for example, and it's an automotive assembly line. Let's say it's doing like the waste, like pickup, like garbage routes or bus driver routes. Why would you want to fire everybody and hire everybody all new when you've already got this workforce that's familiar with how it runs and already knows how to do the job? Why wouldn't you want to keep most of them on? And you do. So typically, the purchaser is going to send out offers of employment to most of the vendor's workforce at some point before the completion date. And where does this become an issue? Like I said, is what happens for these employees that either they don't want to sign on with the purchaser, or they do, and then the purchaser lets them go a short period afterwards, right? And maybe the vendor at this point, what if have become insolvent? They might not even be around to satisfy employment obligations anymore. And the law has kind of been set up in this way to protect employees that find themselves dislocated in this spot, right? Okay. So who's liable for the workforce? It's something that people, of course, when they're doing these transactions, they turn their mind to who do we want to keep on, who do we want to let go. But again, if you just approach it from the corporate commercial kind of perspective and you're not aware of these employment law type of implications that we're going to talk about, you can find yourself facing a big liability as a business that nobody anticipated. And that's the benefit of bringing an employment lawyer to the table, okay? So asset purchase agreement, what's important to understand is that the purchaser who's coming in and buying this enterprise as a going concern is not obligated to extend offers of employment to anybody. Now, typically they will for all the business reasons that I've just mentioned, but they don't have an obligation towards the vendor's employees, okay? It's only if they extend an offer of employment to them that they become obligated to those employees. Why is this an interesting topic? It's because they're not exactly new employees, are they? I mean, they feel like they're new to you, but they're not. I mean, they've been there for a long time. And the law kind of puts special obligations in these circumstances, and it can lead to unexpected liabilities. And when I say the law, I mean both the Employment Standards Act, which imposes something called successor employment obligations. Some of you may have heard of the concept of successor employers, which is under Section 9 of the ESA, and as well under common law, which has been some very recent cases, including at the Ontario Court of Appeal. Okay, so if this employee doesn't want to sign up with the purchaser, then the termination is the vendor's responsibility, essentially, right? And all the obligations that we're talking about, termination and severance pay, it's owed by the vendor. But if they do sign up with the purchaser, well, now you've got an interesting kind of scenario where if the purchaser lets you go, you can make a claim against the purchaser for that dismissal. But if it was within the last couple years of when the business was sold, when the vendor effectively terminated your employment, either because they gave you the termination letter or whatever, because you sold the business and now they've been terminated, you still have a claim against that vendor. And it can lead to a situation where a terminated employee is suing both the purchaser and the vendor. And I can show you without getting too convoluted. I'm just telling you, like, these are some of the issues that you can be faced. But then the question is, who owes the obligations to that employee? And that's the topic that we're going to address today. Okay, so there's a little caveat here. Suzanne was talking about the consideration point, which is you really have to keep that in mind. Anytime you're trying to make a new employment contract or change an existing employment contract, you need consideration, something in exchange to make that contract enforceable. There has been an Ontario Court of Appeal decision in 2016, and this is that second bullet point. That's just because the purchaser is not obligated towards the vendor's employees unless they give them an offer of employment in the first place. That offer of employment is itself consideration sufficient to support the new employment contract. Okay. So that's the second point, because there was no obligation to make it. Okay. And that went to the Ontario Court of Appeal. And I talked to one of the partners from the firm that argued that case, and they still feel that that there wasn't consideration, because the ESA talks about successor employment obligations. Okay, so Section 9 is what sets out successor employer obligations, and now we should be familiar with the Employment Standards Act, that we cannot contract out of the Employment Standards Act. It's not optional. Every employment relationship in Ontario is subject to the minimum requirements of the Employment Standards Act. Now, there's some that we're all familiar with. Some are less familiar to some of us that aren't employment lawyers. But we know, for example, that we can't pay somebody less than the minimum wage in Ontario. That's not an enforceable agreement. Okay. You can't contract out of employment standards. You can't contract around the hours of work, vacation, rest periods. You have to observe those. And some of the lesser known ones, which includes successor employer obligations. What's a successor employer? The successor is the purchaser, who now takes on the vendor's workforce. And what the ESA says is that that employment relationship is deemed to be continuous. That's Section 9. Deemed to be continuous means it's as if the purchaser had been employing those employees right from their original start date with the vendor, for the purposes of the Employment Standards Act only, not for the purposes of common law, which has a slightly different treatment that I'm going to discuss in a moment, but for the purposes of the ESA. And we know under the ESA that we can be obligated to provide up to 8 weeks of notice of termination or payment in lieu of notice. That's 8 weeks of termination pay or notice, and severance pay can be up to 26 weeks under the Ontario Employment Standards Act. 26 plus 8, you're getting to the better part of a year worth of salary for an employee. And what's important to understand is that you can't contract out of employment standards, which includes successor employer obligations. What does this mean for you as a business that's purchasing an entity and you take on that workforce? It means that even if you only employ them for a few weeks, if you want to let them go, you're not going to owe them just the notice of, you're going to owe them their full 8 weeks and their full 26 weeks of severance pay. That's important. That's a successor employer obligation. You can't contract out of that. Absolutely cannot. And it's the same thing with vacation. Okay. If they're entitled to their 4 full weeks of vacation, you can't treat them as if they've only been with you and they're entitled to 1 week of vacation and statutory leaves of absence. And every other obligation under the ESA that's dependent on length of service. That's what you got to understand. As the successor employer, you have to treat that employee as if their start date with the vendor was their start date with you. And that can lead to consequences that people they never anticipated. They always think that's been my employee for 6 months or a year, and I can treat them like that. They never anticipate that this big length of service in the past is going to be recognized under further purposes of the ESA, and even at common law, which is more generous than the ESA, substantially more generous. And it's a slightly different treatment. That's what we're about to turn to. Okay. So what we're saying here, Section 9 of the ESA, as I said, deems that employment relationship to be continuous for the purposes of notice of termination, severance, vacation, and all of the other entitlements that are calculated based on how long that you've been employed. The easy way to remember it is just to think that that's, like I said, that your start date is not the 6 months with you, it's their 20 or 30 years that they've been working with from the company that you took over, essentially. Okay. That's the successor employer under the ESA. What about a common law, right? So here we've got a couple slides, right? You cannot contract out of these employment standards. You just can't, including successor employer obligations, right? So employees who's hired by the purchaser and terminated shortly after, might have a wrongful dismissal action both against the person who's employed them and now fired them shortly after, the person who they were working with for the 20 or 30 years, if you're within the limitation period from when that dismissal occurred, or even both of them in some cases, right? Okay, so after it's been the 2 years are up, this is where it gets complicated, and I apologize in advance, and it gets a little bit technical. I'll do my very best to simplify this. After 2 years, it helps understand the nature of the problem, right? The problem is you've had someone who's given 30 or 40 years of their life, or 20 years or whatever, to this business, okay? And now it's been, you signed up with the purchaser, it's been 2 years, so they're now out of time to sue the vendor for the dismissal that took place when the business was sold. They can only sue the purchaser. And how do we make it fair so that the purchaser's obligation, the purchasers they're over there saying, oh, come on, that's my employee of 2.5 years. I don't owe them this 24 months. What are you talking about? And the courts have made it to protect employees, which is always the goal of employment law. So the couple mechanisms, right? We've got what the ESA does. We saw it, the successor employer, and we're going to see a very similar thing happens at common law, where essentially that length of service with the purchaser gets thrusted upon the vendor, right? And you might not be anticipating this. And that's why it's important to involve an employment lawyer in the team when we're deciding which members of the workforce are we going to keep on and what's the terms of their employment contract to have certainty and so on and so forth, because you're going to be absolutely bedazzled when you let go someone after 2 years and you're getting a claim for 24 months of pay. You're never going to expect that. Okay, so your cause of action for the wrongful dismissal is against the purchaser, but right, that person might have been employed for decades. And now what? We're just going to stick them with, you know, very little notice or termination pay. That's not right. So we get around this problem. And as I said, the goal is to protect employees. So we've seen the mechanism of successor employer obligations. That's how the Ontario legislature is doing it through the Employment Standards Act. And at common law as well, courts in Ontario recognize the experience of the employee with the vendor in determining the amount of notice that's owed, which means the amount of severance by the purchaser. And there's good reasons for doing that. One is to protect the employee. Two, it's recognizing the fact, and here's the leading cases, which I've gone through all of them. It's recognizing the fact that that vendor, or sorry, that purchaser has gained a benefit from hiring that person who was already familiar with the operations, has been doing the job for decades. They didn't have to train someone. They skipped all the process of hiring. How fun, is that a fun activity? We don't enjoy it. Hiring, going through the recruitment, ongoing interviews, a lot of time, a lot of money, training people. Some of them don't work out, gotta let them go, so on and so forth. You get to skip all of that and you just bring someone on board that's already been doing the job successfully for 20, 30 years. Well, that's a big benefit to you, isn't it? And it wouldn't be fair for you to treat them as if they're 2 years fresh on the job. And that's sort of the balance that the courts are striking here, basically, by making you as the purchaser liable towards that employee as if you had employed them all along. And keep in mind, in the context of a share, we wouldn't even be discussing it because the legal identity is the same. The conclusion of this portion of the presentation is that both under the statute and at the common law, the court is treating it as if that employment relationship had been essentially more or less continuous. Not exactly, but it's an easy way to think about it.
Or a merger.
Yeah, exactly. Okay, so again, we'd like to pause, take an opportunity for any questions, maybe check in on the time before we proceed to our final topic for today.
Any
Right,
questions?
10:26. So you're doing good on time. Any
Brilliant.
questions? Does anybody want to unmute?
Will you be taking questions at the end?
Yes, we will.
Because I do have a question regarding the share purchase and a company that did not prior have any employment contracts whatsoever, and now I have to make them. So I do have a question regarding that.
Might as well do it at this point before we move on, or
Totally up to you, Nick. We're happy to address it now or at the end.
Okay, so uh, again, I'll reiterate, it's a share purchase and there is no prior employment contracts. We kept all the employees. So I'm making employment contracts now, and I want to make sure that all the employees, like I put their actual start dates in there as the commencement date, but obviously the signing date will be, let's say, for lack of a better date, today. So
Yeah.
like I'm approaching this correctly, am I not? And these contracts are all indefinite. I'm not as familiar, obviously, with employment law as you are, but I don't like, I forget the term you use, but
next term.
fixed term contracts. I didn't like them to begin with, so they're all indefinite.
Perfect. It sounds like you're on the right track, Nick. I like what you're doing. I like that you want to use indefinite contracts. I like that you're recognizing for, the distinction between commencement date and signing date. So you're recognizing the commencement with the company that you took over for their purpose. Good. You're already on the right track. You're checking the right boxes. The thing to keep in mind when you provide an employment contract, and the advice that we always try to give people, right? You need a consideration, right? You need to give them something. A signing bonus is the most straightforward and easy way to do it, okay? To give them an amount of money in exchange for signing the contract. Now, you want to have a termination provision in the employment contract, okay? Don't just limit them to only the Employment Standards Act. They're 8 weeks when you're doing that. I mean, obviously seek an employment lawyer. I hope you're not drafting these up yourself. We would be able to help you with them, or somebody else. You should seek a legal advice with an employment contract. It's very hard to draft it and get it right. But when you go to that termination section, Nick, think about what would you be willing to offer that is fair to somebody, and think about what would you like to receive if you had worked for a company for 20 or 30 years on termination of employment, right? If you put just the 8 weeks minimum under the ESA, you're going to run into problems. Our advice is to always be at least a little bit more generous than that. For example, you could offer, so the ESA offers 1 week. That's it, 1 week up to a maximum of 8 weeks. You could say, for example, 2 weeks per year of service up to a maximum of, I don't know, 26 weeks, 30 weeks, 52 weeks, if you want to be very generous. Have some uncertainty as to, that's the whole benefit, is having a contract that specifies clearly what you're going to receive on termination of employment. Our general advice is be more generous than just the bare minimum, because if you try to stick them with just the minimum, you're really increasing the likelihood that they're going to push back when you do terminate, and that your employment agreement is not going to be enforceable. And if it's not enforceable, then what was the point of having it?
Yeah, and the courts, like I indicated earlier, termination clause that limited to the Employment Standard Act, the court have a tendency of wanting to kick that to the curb because they find it's not fair. And the reality is, if you've worked there for 20 years, is it fair to only get 8 weeks after you've invested all that time with that company?
Right.
So,
I understand your argument when it comes to somebody who's been employed for a very long time, but you can stick to a termination clause for, like, an employee that's just like 1 year or 2 years, right? Like if it's short term, the ESA standard should be just fine.
but even then, even though it's short term, it's still the bare minimum, and it depends of the position that they're holding. And if you have an employment contract that limits it to that, you are entitled to do that, but you want the latest versions of the termination clause that have been accepted by the courts now. But that clause of today may be kicked to the curb next year by another court.
When it comes to consideration for signing the contract, is there a specific amount? Can I say I'll give you $1 and that's the consideration for signing the contract?
I wouldn't get cute with it, Nick. The law does say technically that, you know, any consideration is a good consideration, but that's not what we recommend clients to do. You know, it should be at the minimum a few weeks of their salary, what they were gonna earn, you know, even like $100 or a couple $100. I wouldn't, because that's gonna be the glue that you're gonna say that this contract should be enforced because I gave them something for it. It should be something reasonable. Again, same reason why I recommend don't try to stick them to the bare minimum. Don't offer some measly consideration and hope that that's going to stand up. You know, a couple $1,000, something like that. You know, maybe an extra week of vacation for the year than they were entitled to. Something reasonable, some kind of benefit for them, right? Another point, just very briefly to address your previous point, Nick. Yes, I understand the feeling. It's just been 1 year or 2 years. Length of service is only one of the factors that goes into it. Another important factor is their age, for example, right? The courts recognize that someone who's terminated when they're in their mid-50s is in a very different position than somebody in their earlier 20s or 30s in the job market. It's harder to find a job, isn't it? Or the same thing if it's a very senior position, right? Again, they recognize it's a lot easier to find a junior entry level position than it is to find an executive level position that includes like a stock options and stuff like that. You might be searching for a job for a much longer time. So length of service, I would tell you, is the most important factor, but it's not the only factor.
Okay, I'll just poke your brain one more time. So if you don't mind.
Yeah, no, that's why we're glad. Please do. Yeah.
Okay. So I just feel more comfortable having an actual employment contract. So let's say hypothetically, because this company had none whatsoever, and you just continue with none. Well, is that worse than making one that you say, quote unquote, is not really going to be up to snuff?
Well, that's what I'm suggesting, that you should work with an employment lawyer to do that, to give you the best chance that it will be up to snuff. The one thing, again, to caveat to this, it's a bit of a play on words. There's always an employment contract. Every single employment relationship is a contractual relationship. The difference is if you don't have a written document setting out the terms, then there's not very much certainty of what the terms are. And it's easier for an employee to, for example, say, actually, we agree to this and that, as opposed to if it's not set out in a written document, right? So yeah, as employers, we always recommend employers to use contracts to bring certainty to written contracts to bring certainty to what the terms are. It limits liability. It avoids a lot of cases being, you know, getting lawyers involved and litigated that could have been settled straightforward when there's certainty as to the terms. But of course, we're going to recommend that you should use an employment lawyer to give you an enforceable agreement, or an agreement that has the best chance of being enforceable is probably a better way of putting it than just some template that people have been using that they got from I'm not sure where, and it's probably not, it's very little better than just keeping it as it is right now, the status quo with no contract. A bad contract is basically the same thing as having no contract at all.
Thank you very much for answering my questions.
No problem at all. So we have, and again, encourage questions and discussions from anybody else in the audience. We have one more topic with the remaining time today. I am going to take a very short break, but Suzanne will get it started for us.
Okay. So basically, we're going to discuss on the issue of developments in the law of dismissal. So basically, provincially regulated employers can terminate an employee at any time for any reason, as long as they provide, be it reasonable notice of the termination or payment in lieu of a notice. And so in Ontario, you can terminate somebody because you don't like the color of their socks, really, as long as you pay them the right amount of dollars. If you're dealing with a federal employer, like a First Nation, for example, that have been working for the employee has been working for more than 1 year, they are governed by a different law, which is called the Canada Labor Code. And after 1 year, they can only be terminated for just cause. And just cause is a very difficult thing to prove. The courts are, what you may think is is a just cause that you've lost the trust in the employee. The courts may not see it like you think. 90 to 95% of employers that terminate alleging just cause, in fact, cannot prove just cause. And provincially, there's no obligation to apply progressive discipline to be able to terminate for just cause. It could be a single incident. It could be that just toppled the vase, or it could be a series of incidents that cumulatively you've come to the conclusion that it is just cause. But like I said, it's not so easy to prove. And an employee that's been terminated for just cause basically is not owed any money whatsoever for reasonable notice or payment in the year. So basically, they're getting paid the amount of money that they've earned up to that date, vacation pay, if they're entitled to paid sick days and they're entitled to it on termination, they would receive that, but they will not receive any type of termination pay or severance pay. So what happens, an employee that that is terminated for just cause has every incentive to want to sue you. And the reason is he's got nothing to lose. The thing is, he's lost everything. He's lost his job. He's not going to be entitled to EI at first when he first applies, because he's been terminated for cause. So EI says, if you've done something to ruin the employment relationship, we're not going to pay you. The employee at that point, it's worth going to get legal advice saying, do I have a case here? Maybe the contract is not enforceable. And there's many reasons that a contract can be unenforceable. Not only the termination clause, example, an employee that started to work and then got the employment contract signed a few days or a few weeks later because the employer was too busy to get it done. That employment contract, even if it's signed, is not worth the paper it's written on. Because unless the employer has provided the employee additional considerations, such as a signing bonus, to glue this agreement together. So basically, if you're going to alleged cause, be ready for a dispute, as opposed to a termination without alleging cause. The thing is, your employment contract will make the employee a little bit more hesitant to consult and to incur legal fees if it's set out in there what they're entitled to.
Perfect. So on our final topic today, we're going to talk about termination for cause generally, which is what Suzanne did, but there's a very recent topic as well, which is only in the last few years. Well, it's been around for a while, but in the last few years, it's been getting a lot of attention in the employment law bar, and it's causing a lot of headaches for employers. And that we will cover that in some recent decisions, including with the Ontario Court of Appeal. What I would like to say generally about termination of employment, whenever somebody calls me and says, we've got this employee that we want to let go, I'm always going to, 9 times out of 10, I'm going to recommend that I would say more than that, actually, probably,
10 out of 10.
10 out of 10. We're going to tell them, even if you do think there's cause, okay? Because, to just offer them something, because as the employer, you want to get on with your business. You don't want to get dragged into litigation. You don't want them to be hiring lawyers, or if they do hire a lawyer, then it's just about let's negotiate a number. It's not about, I'm not paying you anything and good luck and see me in court. That's not that's a recipe for you know,
Disaster.
well, it's a recipe for a lot of time, a lot of expenses, a lot of hurt feelings, a lot of emotional exhaustion on both sides. And it's just taking away from business. Every minute that you spend on the phone with your lawyer, hundreds of dollars an hour trying to drum up a case of cause, you always have to think from a business perspective, why didn't I just offer them some kind of severance and get them to sign a release? So I'm always going to try to gear people towards doing a termination without cause. And the other big picture point that I want to make here is, again, what's intuitive to regular people and what's intuitive, and I don't mean regular, but you know what I mean? It's counterintuitive again. It's a theme of this presentation. What you might think is cause or what you think is outrageous is not the same standard. The court sets an incredibly high standard at common law, and we're going to look at the standard that's set under the ESA, which is even higher to really protect the employees. So minor things like, you know, you think they're not doing that great of a job, their work's been a little bit sloppy, you don't like the way they're talking to coworkers, customers, clients, big things that I'll give the umbrella term personality conflicts. It falls way short of the standard for just cause for dismissal, okay? Just cause for dismissal is incredibly narrow. There's a few things that tend to check the box, such as fraud, you know, like an employee stealing from you, writing themselves checks, that kind of thing. You know, you can't be expected to, you know, give them reasonable notice that their employment is going to terminate, you know, or you're not expected to say, oh, you know, please don't defraud me in the future. I mean, you can let that person go at once and without paying them anything, but you
You
know,
need to be able to prove this fraud or this theft.
Yeah,
You know, you may suspect it,
right.
but the thing is proving it is a different story.
you have the obligation as the employer to prove, the onus of proof is on you. It's not on them to, the employee to prove they weren't guilty of cause. It's on you to prove that you are guilty of cause, and it's a very high standard of proof, and for good reasons. And again, is a theme consistent? I hope the themes are seeming kind of consistent, right? It's kind of miserly, just like sticking somebody with 8 weeks. It's kind of cheap for you to say, you know, you are so bad and we're not paying you anything. In the vast majority of cases, the court says, okay, if you're not happy with an employee, you guys don't have to stay together forever. You can bring the relationship to an end, but you're expected and not expected. It's your legal obligation either to give this employee enough advance notice that their job's going to come to an end, which means you've got a job for 6 months after you don't, or whatever it might be. Or if you don't want to keep them around anymore, which is in the vast majority of cases, you don't want a despondent terminated employee walking around the office and knows their days are numbered and they're saying bad things about the boss to everybody and they still have access to the computer. You probably don't want that. Then you're going to have to pay them money instead of giving them notice of termination.
Because once an employee has been, from my experience anyway, from the time the employee receives notice that the employment is going to come to an end, some employers like to say, well, I'll get my money's worth out of this employee. But once the employee knows that their days are numbered with you, they've lost all interest. They've lost all interest in being productive. They're more preoccupied at finding another job. They're more preoccupied with how they're going to make their obligations, meet their obligations if they don't. So you've got an employee that's unstable. And the thing is also, you may have an employee that's mad and decide to be destructive, you know, do some stuff with your bookkeeping or accounting or invoicing that, you know, make an error, you know, and that those errors can be very costly. So my experience is that once you've decided to bring an end to the employment relationship, it's a lot more productive to pay them and get them out. This way here, they're moving on with their life, you're moving on with yours, and also less of an opportunity of creating a very poisoned work environment for the rest of the workers.
Can I just check in one more time with the time? Because I want to make sure we finish on time and leave at least 5-10 minutes for questions at the end.
Sure. So right now it's 10:46. So we have 14 minutes left. Yes.
Brilliant. Okay, so we're going to wrap this presentation in about 5 minutes, and we'll leave if there's any more questions for the audience. Okay, so I'm sure you've heard before, this isn't, I hope it's not the first time that you're hearing, it's a high standard of cause. Be careful if you're going to fire somebody for cause. Not only you're opening the door, but also, you know, you might have hurt somebody's reputation with your allegation of cause. We saw that in the previous one that we looked at, saying he was responsible for the death, that type of thing. There can be reputational harm, can lead to additional damages. Just probably don't go down this door, okay? And here's the new development that's new in the case law that I wanted to cover in this section of the presentation, okay? So like, remember what I was saying about employment standards, you can't contact out of the employment standards. And remember what I was talking about, please stop using these like old agreements from how knows how long they've been on the shelf, or that you got off the internet from the, you know, human resources download center of, you know. The problem is that here's a recent, this has been in recent cases of the Ontario Court of Appeal. The Ontario Employment Standards Act termination of severance regulation, it's 28801 under the ESA, has an even higher standard of cause than the common law, which is already really high. Here's what that one says, okay? Employees must receive termination or pay in lieu thereof, and this is the same standards from severance pay. That means they're 8 weeks or up to 26 weeks under the ESA, unless the employee has been guilty of, in quotes, willful misconduct, disobedience, or willful neglect of duty that's not trivial and hasn't been condoned by the employer. Wow, that is good luck convincing somebody that they've meant that. That is such an elevated standard. I don't even think of how I could word it to make it a stronger standard than that. It's so high, you're going to have next to no chance of proving it. There's been recent cases under the Ontario Court of Appeal where the court said, you know what, this person was really bad. You satisfied common law cause, but you didn't satisfy this ESA standard, and they're still owed their. So again, practical advice, if you're going to terminate somebody, at a bare minimum, give them what they're owed under the Employment Standards Act for termination and severance pay. And what's this new trend that I'm talking about? And why did I just tell you about those employment template agreements? Because typically they'll, in their termination section, they'll have the without cause and for cause provisions. Without cause will say we can terminate you anytime, so on and so forth, by providing you ESA notice, and that's what the typical language. And there'll be typically another clause comes right after it, says termination for cause, and it'll say something to the effect, employee may terminate the employee for any time without notice or payment for cause, for conduct that constitute cause. And sometimes it might have a list of like A, B, C, which might include, for example, breaches of confidentiality, insubordination. There might be this little checklist of things. And these new cases, and we've included one which we won't go through in the interest of time to kind of leave some space for the audience. The Ontario Court of Appeal has said, well, your little laundry list of what constitutes cause for dismissal is not the same thing as this willful misconduct standard set by the regulation. In other words, you've set a different standard for cause in your employment contract. Your employment contract saying you can terminate someone who's being insubordinate or breach their confidentiality or whatever else and not pay them anything. But what does the ESA say is that you still owe them unless they've done this incredible bad thing. So actually, your employment contract is trying to contract out of the Employment Standards Act. I know this is not intuitive, but it's the same thing as if you tried to say, I'll pay somebody $8 an hour, or you have to work every day on weekends and whatever else. It's the same thing as trying to you're contracting out of the ESA. It makes your employment contract, the termination provisions, null and void, which means if you had, and what's the kicker? Is that even in these cases, the Ontario Court of Appeal cases, they weren't even terminations for cause. They were without cause terminations, and they had a provision in there that said, whatever, 2 weeks, 3 weeks per year of service would have been enforceable. The employer would have been able to limit their severance obligation through the employer. But the problem was they had a contract, a thing in there saying we can terminate you for cause, and they had their different definition of cause less than this. And the Ontario Court of Appeal looked at that and said, I'm sorry, you've tried to contract out of an employment standard. As a result, your without cause termination provision is invalid
As well.
because your for cause provision was invalid. And if you think that you're gonna recognize that, or the HR database online of contracts is up to date, there's just no chance. And I can tell you, every time that someone who's terminated calls me and looks for help getting a severance, I look at the employment contract, I go right to the for cause provision, because I know if that contract hasn't been updated in the last few years, it's going to have that kind of language. And right there, that's my opening, amongst probably several other openings in the termination provision or lack of consideration and so on and so forth. What's the lesson? What's the moral of this story? Use an employment lawyer. The law is changing all the time. Like Suzanne said, get it done, keep checking on it. You know, it's not just a set it and forget it. It's not like a slow cooker. You don't, you know, keep it on the shelf for a long time. It's not going to do you a service. That's what I wanted to cover in this section of the presentation. The difference between first cause generally, and then that elevated standard under the ESA, and how that can have an implication that there's just no way that you're expecting. And even lawyers, good, competent lawyers that are fantastic at doing business transactions and corporate and commercial stuff, but they're not reading, because these cases are coming out all the time, and they're not specifically specialized in employment law, which I hope that this presentation, I try my best not to be too technical, but obviously there's some technical aspects that you know what I mean, and that there's just no way people are going to pick up on it unless that you're knowledgeable about this area of the law specifically. And that's the benefit of having employment law advice when you're doing major business transactions and things impacting your business. So in the interest of time, this is just a case just illustrating that exact principle that I just told you, the difference between that ESA standard and the common law standard and what that meant for the termination provisions, right? So here's this definition of cause under this employment contract. Conflicts of interest, documented unsatisfactory performance. What did the ESA say? That willful misconduct, really high standard, not just we don't like your performance. What was the result? That termination, all the termination provisions were invalid, and it's like they had no contract at all. Not like it's still, you know, doesn't just kick the rest of the contract, like still the stuff about hours of work and pay and stuff, but for the purposes that they're concerned about, which is what do we owe you when we fired you, it's like you had no contract at all. And there was damages in this case, 60,000. Okay, so thank you everybody. Thank you for having us. We enjoy doing this program. We're really passionate about this practice area. And at this juncture, we invite any questions from the audience relating to the topics in this presentation, or even just generally relating to employment law.
Hi, Suzanne.
Hi.
This is really a great interaction, and I feel that I need more information. I'm ready to hear. It's really interesting and very knowledgeable. So if you can conduct one more session on this, would be really helpful.
We're having a hard time understanding you, and the voice seems to be bouncing.
It's right. Are you able to hear me right now? A bit better?
It might be better for you just to maybe put it into the chat and we can read it out. Might be a better option.
Sure. I'm going to do that.
Thank you very much. We'll be happy to answer your question, and as well, also one point I didn't mention, we're gonna send this slide deck to the Timmins Chamber so that it will be sent to all the participants, and I believe there's a recording as well.
Sure. Robert, did you want to take a look at, there's a question in the chat box from Renee. Can updated contracts using correct language be drafted and replace original employment contracts, not fixed term?
Yeah, okay, it's a good question. So yes, the answer is yes, but there's a couple points. You want to have the consideration piece, which we've touched on a couple of times. You would want to have a substantial a fair signing bonus, okay? And also it's important that you know, there should be a good reason for introducing the new employment contract besides just that we want to put a termination clause in, essentially, okay? Because if it looks like that was the only reason that it was in there, again, that could be another potential avenue that this contract could be found unenforceable. So in other words, if it should be, the timing should be coincident when it would make sense to bring out a new employment contract because the person's received a new promotion or they're being transferred to another department or something like that, then it would make sense. If it's just all of a sudden out of the blue, you know, I want to roll out these contracts and stick people with termination provisions. I'm not saying that you can't do it. I'm just saying that's, again, another avenue where it would be better if it would be a logical sort of timing of doing it, as opposed to it just looks to the judge that the only reason that you brought these new contracts out was to try and take people's termination entitlements away.
Another example of that would be at a good time would be at a time where you're wanting to give a raise to an employee. So this is a good time where they have the incentive to want to sign it. If you want, there's a carrot kind of wanting to get the raise and the signing bonus that you're gonna come up with. The other thing as well is could be at a time where you're considering providing benefits to employees. You know, again, it's a good opportunity at that point to get an employment contract that's enforceable. And the thing is that from the practical side, my suggestion to you is have your employment contracts reviewed on a yearly basis. Because like I said, in as much as I've been practicing for 38, but doing employment law for 22, the law has really evolved in the last few years, and you want to be on top of that. You don't want to be investing in doing employment contracts and and then leave it there for 5 years, don't touch it, and then realize that you're still faced with the problem that the employment contract is unenforceable. So the thing is that you want to, it's possible that the employment contract will be still good after a year, but it's worth investing in having it reviewed. And if it's the termination provision that needs to be amended, again, there's always a possibility of updating contracts. You need to have an additional consideration for existing employees. For new employees, it will obviously protect yourself, and you don't need to give that additional consideration because the job itself is the consideration.
See, we have another question in the chat. Thank you for typing it out, by the way. I'm not sure. I think it was kind of echoing. I was having a hard time. Yeah, so it's about, first of all, thank you for your feedback about the course. Or the presentation. We enjoy doing it, and then be pleased to do future sessions. If people have specific topics of interest, you could either contact us or contact the chamber, and we can see about gearing a presentation towards what people are interested in. Of course, if you need, you know, specific employment law services for your business, you can always privately retain us. There's a question about what about terminations in the probationary period? This is another topic that just like fixed term employment contracts, I really advise employers to stop having those probationary periods automatically in everybody's employment agreement. And it seems to be in the template. I just see it all the time. First 3 months are probationary, first 6 months. I have a question. Why does everybody have to be probationary? I mean, you're just going to introduce, again, you're going to introduce avenues of uncertainty that you may not be planning for. One is that, you know, you're expected to conduct a performance evaluation on a probationary employee within their probationary period. Another is that the reason that these can be a problem, okay, is because typically in those probation clauses it'll include language to the effect that employer may terminate employee with any time within the probationary period. Problem with that is that you can, again, unintentionally, without knowing it, be contracting out of the Employment Standards Act, because the Employment Standards Act does not say probationary quote unquote employees aren't owed notice of termination or pay in lieu of termination. So if you have language in there that's saying you can terminate without giving them anything, again, that you can be unintentionally in contracting out of the employment contract, Sarah's Act, and this could be long after, this could be years after they've cleared whatever probation that you've set there and you've terminated them and you had a without cause thing that would have maybe otherwise been enforceable, but you've got some language in there that can be interpreted as contracting out of the Employment Standards Act. And again, you've essentially opened the door for an employee side lawyer to say that you essentially have contracted out of the ESA and your termination provision is not good and we're owed much more money as a result. So I recommend getting away from probationary in the employment contract. It doesn't do a lot of benefit for employers. Again, I know this is counterintuitive. You think you're protecting yourselves by keeping it in there. You're actually exposing yourself. You're committing that you're going to do this performance evaluation and work with these probationary employees when you otherwise wouldn't necessarily have this obligation. And the other reason it gets problematic is employers falsely assume that if someone's probationary, they can just treat them as like a lesser employee, that they can write them up or not give them the same sort of respect or just terminate them at will, which is not the case at all.
Particularly if you have a probationary period of 6 months. The Employment Standard Act indicates if you want to terminate an employee after 3 months of employment and before 1 year, that basically you will owe this employee a week's salary. So your 6 months probation is not protecting you from that. You still owe it. So why put a burden on yourself as the employer? The other thing too is if you have a probationary clause, the courts will look at it from in the context of that you have the employee needs to be given an opportunity to learn. The thing is, if you don't have that clause, the thing is if the employee does not meet your requirements, you can terminate them within the first 3 months without notice. So why add that additional burden of the employee needs to have that opportunity to show that he or she can do this job?
Be suitable for full-time employment. So I see we have got a follow-up question which says we are following the ESA, right? So we're providing what the ESA says based on the length of service. So again, so just to Suzanne's point, then great. Then why do you need the additional step of calling somebody probationary? It's doing very little benefit from you, and it's opening the door to an employee side lawyer essentially saying that your termination provision might not be valid because of your language in your probationary clause. You're introducing this obligation of conducting a probationary performance evaluation, that we've talked about. And also, I like to make things simple for my clients. I like to take away all these categories of probationary, part-time, full-time, casual. It just introduces confusion. It just introduces ways for people to go wrong and to think that they're okay to treat different employees differently and essentially, so that would be the advice. To the follow-up question of do you suggest any standard contract to follow by employers? If everyone is a little bit different. We don't reinvent the wheel every single time. We start from a template ourselves, so don't get us wrong. But what's an appropriate employment contract for, like, for your entry level, like receptionist, and is very different from what's important for somebody who's has a lot of trust and responsibility and financial management in your organization. So just using the one size does not fit all. And essentially, you always want to be thinking about, you don't want to just grab some generic language, right? So like if you're in like a financial regulatory business, you want the provisions to be based on that, right? If someone's a commissioned salesperson, you want provisions in there about when is a commission earned and that kind of thing, not just general provisions from the internet or I don't know where. So yeah.
It needs to be adapted to the type of work that is being done. Obviously, an upper management employee is going to have a very different type of contract than a clerk, you
Right.
know, and just in terms of responsibilities, in terms of what the expectations are, et cetera, et cetera.
Great. Well, thank you so much. I see the time, we've gone over a couple of minutes, but I'm glad that you were able to answer the questions of our attendees. So Suzanne and Robert, thank you so much for sharing all of your expertise. As we mentioned, I will receive your PowerPoint. I'll send it to the attendees along with the recording of today's session. Just a quick thank you to Newmont Porcupine, our Reimagine Resiliency series partner for helping, as well as today's session partners, Genie Financial, Maisonneuve, Dawkins Lawyers, and MNP. And we'll send the information. And if you do have other questions, please direct them either to the chamber or to Suzanne and Robert. So thanks so much and enjoy the rest of your day.
Thank you for
Thank you.
having us.
You're welcome. Bye.
Thank you so much.